Now before you rage, click away and leave a nasty comment and thumbs down the video. Understand this isn't like me hating on him or attacking him. We have two very different jobs and what we do in this whole Second Amendment space, and that's what I'm going to explain in this particular video. And guys, don't forget to shop at onlytacticalfans.shopify.com. I'm permanently demonetized from YouTube. That's how I pay my bills. I have a bunch of survival gear there, MREs, tourniquets, other survival gear, really cool stuff. Check it out. Anyways, let's get into the topic. What am I talking about here? All right, so first you got Mark and you got CRS. What are our two different jobs? He's an actual lawyer. So what he does in his video is breaks down the geeky stuff. So he'll go like 1 + 2 + 7 - 5 = 5. Essentially, he'll take a topic, completely explode it out, dissect it, tear open the guts, and go through it point by point so you fully understand exactly what's going on the lawyer side of things when it comes to like the Supreme Court. More importantly, Second Amendment rights, because that's all federal court, so that's a lot what he covers. What I do is I take my videos, which I just cut out all the math, and I go, because 5, X exists, right? So no, I don't go through 1 + 2 + 7 - 5 = 5, 5 = X, X + 5 is the answer. I just jump all that out, and I'll take a 30-minute video, and I'll compress it down into like one sentence. Because of 5. So what my job is to watch videos in channels like Mark, and I take these extremely complex topics that make you want to claw your eyes out, and I compress it down into something, and I put it in an entertaining package, and I deliver it to you. So if you're a blue-collar worker and you just spent all day, I don't know, at the steel mill or something like that, or welding, or truck driving, and you don't have 30 minutes of your life to understand how we arrive at 5, I eliminate all that out and I start with, hey, we're at 5, so this is probably what's going to happen. And I make guesses off of that information. Basically, I'm reporting on what the lawyers do. I'm not trying to be a lawyer, like I'll never go for my bars lessons or try to talk in front of the court, because that's not what I'm trying to do. I'm not trying to do all the grunt work and all that. I'm just looking at what they did and I'm telling you what they did. I'm reporting on their work. And it's not just Mark's channel. There's a whole bunch of channels I watch, like piles and piles of them. Mark's channel is more for the creators to watch. We're supposed to watch that. When I say the creators, I'm talking about like the Second Amendment, reporting, talking heads. We're the Second Amendment news for you guys. We're supposed to watch all these channels, understand the geekiness, and then make informed decisions with that information. Take hours of video, hours and hours of research, push it down into 10 minutes, and serve it to you in an entertaining fashion. So, for example, 922.0, that's what's coming up right now. It was like a 28-minute video he just put out explaining that Article 1 is Congress's power. That's what they're able to actually do something like 922.0 with, but they did it incorrectly. They screwed up the taxing thing. That what they put out themselves on 922 is incorrect, but it goes farther than that. It's also that the ATF interpreted this with Chevron deference and rewrote the statute in something that goes anti-gun when it never should have been that way. So basically, these states like West Virginia and Kentucky, should they push through, they're almost guaranteed to remove the Hughes Amendment. If not, they're almost guaranteed to operate inside of it, because either the ATF's got to be like, okay, you can operate inside of it, and we'll leave it alone, and then just those two states are selling machine guns, or they're going to be like, no, you can't, and what's going to happen is they're going to sue, and because 922.0 is built off of bad Congress authority plus Chevron deference, it'll fall. It doesn't have a leg to stand on. It got chopped the shit down. So, that whole thing was a 30-minute video, and I compress it down into, what, 2 minutes here? That's my job. That's what I'm supposed to do. That's what I'm here to do. So, what are we going on here? Now, I got a comment, this comment right here, basically asking, like, saying that, hey, this is stupid, we shouldn't be going after, like, 922 on that right now because Mark says we should hit it in incremental cases, and you are 100% correct. Great information. That is exactly how it should be done. Now, he believes, and I agree with him, that first we should have an SBR win. We have legal rifles protected by the Second Amendment. We got legal pistols protected by the Second Amendment. Why is the firearm in between those not protected? We need to get a win that says, yes, even SBSs and SBRs, short barrel rifles and short barrel shotguns, are also protected by the Second Amendment. That needs to happen. Next, we need to get them to say that AR-15s by name, because it's the most owned firearm in America, is protected by the Second Amendment because that's America's rifle. And now what they're going to have to do after that is explain what AR-15s are protected by the Second Amendment. Long ones, short ones, black ones, pink ones, purple, ultimately all of them, including full auto. So, that is the way he believes it should be done. And the comment was basically like, hey, stop pursuing this, stop chasing your tail, it's too soon. If you guys take full auto laws to the Supreme Court right now, they're going to fail. Unfortunately, that's not the way things are. Yes, his strategy is better, but the timeline isn't waiting for him. Ready or not, here we come. Now let me explain why. So the Brewin decision dropped June 23rd, 2022. So anybody that was about to go to trial or just went through trial or something like that, now the Brewin decision attached to cases in 2022, 2023, and all the cases after it. So immediately, June, all these cases are like, hey, Judge, well, the Brewin decision just said that you have to look at text, history, and tradition. We're gonna narrow this down. We're gonna get rid of all the other gun cases. We're just looking at machine gun cases. So either the cases were dropped immediately, which the Brewin decision was applied, or the judge responded like my judge did. No, we do not have to do the Brewin test in this gun case because this is a dangerous and unusual firearm. Yes, I know a drawing on a piece of metal should have never been considered a firearm, but that's the way it is. So they're going to be like, that's a dangerous and unusual firearm, so therefore Brewin does not apply to that particular case. Okay? So that's 2023. So, all right, the judge forces the case to trial. We're like, you know what? We're going to trial because we know Brewin does apply. We know we're right. We know that machine guns are definitely protected by the Second Amendment. Brewin says so. Machine gun laws, the earliest you could go back is 1934. 1934 is not 1791, and dangerous and unusual is not a gun registration. Dangerous and unusual is a brandishing charge. I've already went through this in detail in videos. Essentially, it breaks down like this. There's nothing, you haven't broke any laws, and you haven't hurt someone, but you're scaring the shit out of the public. You're brandishing a weapon. That's where dangerous and unusual came in, is you have a weapon that's dangerous, and it's unusual for you to have that weapon, and you're scaring the public. Here's a way for them to charge you. It's basically a catch-all. You haven't hurt anyone, but you're scaring the shit out of people. So that was the stopgap there. And a fray, which is where dangerous and unusual comes from, is a brandishing charge. Basically, disorderly conduct light, if that makes sense. So, they're saying that because dangerous and unusual or an affray existed before the Second Amendment, and that's proof that guns have regulations. Basically, it's incorrect history. And they used it in Heller because Heller, the NFA had come up, and they're like, according to Miller, you know, full autos should be protected because that's a military weapon. And they're like, well, you know, well, dangerous and unusual existed before, and that's historical context that, yes, it's okay to completely regulate a class of weapon away from the public, and that's all right. It was incorrect history. Completely made up. They just took a law, they took one phrase out of it, dangerous and unusual, and the fact that it's related to weapons, and slapped them together and basically bastardized their own history. So anyways, dangerous and unusual gets applied sometime in 2022. It circumvents Brewin. So now the cases go to trial. Trial from, like, you would still be in your motion stage. From going from your motion stage to trial being done, you're looking at 9 to 18 months. So now you're looking at the case for does dangerous and unusual circumvent the Brewin decision is going to be about 2023, 2024, they've been found guilty. All right, so now you go to the appellate levels. You got motions to be filed, you have oral arguments, there's just a whole bunch of stuff that happens. From the time you get convicted to, all right, so you get convicted, you have to sit in jail. You can't do anything. The judge will let you rot in jail for 6 to 7 months. Now you can finally go to prison. That's when you can put in your motion, hey, we're going to do an appeal. From that time of putting in that motion, you're looking at 12 to 18 months. That also includes your jail time. So now the case is at 2025, 2026. That's where we're at right now. Dangerous and unusual is just hitting the 3-judge panels. Does Brewin cover dangerous and unusual? We're just getting the 3-judge panels. Tate already lost. So his is actually advanced past that. But mine, because my case hit at the exact same time the Brewin decision dropped, we're at the 3-judge panels. Should we lose at the 3-judge panel and they're asking for extra information in my case, which means they've moved past combination of parts, which was a big non-starter. So if we move past combination of parts, well, now one of the things our appeal attacks on is the Brewin decision. Why was the Brewin decision not allowed to be applied in my case when it's case law? That's what the Supreme Court said. Why did we not have the ability to go back and test the text, history, and tradition when it comes to my particular case? Because dangerous and unusual, I don't remember in the Brewin decision saying you can still use a 2-step balancing process if dangerous and unusual is included. No, they said 2 steps is 1 step too far. All you're supposed to do is look at the text, history, and tradition around the time of the founding of the Second Amendment. It didn't say, or if it's dangerous and unusual, it doesn't matter. So, now, let's pretend I lose at the 3-judge panel. Now we go to en banc. That's a 6-judge panel. We're looking at another 8 to 14 months. That puts us into 2027. So if we lose there, probably spring of 2028, we'll have an answer from Supreme Court. Does dangerous and unusual eliminate the burden of the Brewin decision? So like I said, ready or not, my case is one of the first cases. Tate's going to beat me there, but because he didn't get an en banc trial, they may not take that case. I don't know. From what I understand, the Supreme Court just likes to have all the legwork done so they can look at all the facts and just make a ruling. So they want it to go through the 3-judge panel, the circuit judge, the 6th judge, and now, okay, everything's done. We're going to look at everything and we're going to make a decision. From what I understand, that's what they like to do. Because he got skipped on one of the processes, and that's not his fault. The 6th judge was just like, you know what, this is so ingrained in law, and it's so sure there's no point in us even looking at it. Remember, he got convicted for possessing something that was legal in 2003, maybe even later. The AKF got green light that. That part existed from 2003. Later, they changed their determination on what needs to be parts, like how destroyed it actually needs to be. Because he had an older one, that's what they convicted him on. Wild. So anyways, he skipped past that. So now it's going to be in front of SCOTUS. Depending on how SCOTUS goes, his case might decide, does Brewin eliminate the burden of dangerous and unusual? I don't know the exact of his cases, but I'm assuming the Brewin decision is in there somewhere. I don't know. He might have actually been convicted before the Brewin decision. My case may be the first case that goes to the Supreme Court that tests Brewin against dangerous and unusual should I lose at the 3-judge panel. Anyways, so that's the difference. He does the nerdy stuff. I report on stuff that people like him do. I report on other lawyers. I'm not a lawyer. I'm just a reporter. I do believe his timeline is wrong. Yes, I would like to have it go through all these steps before we test dangerous and unusual, but it's not going to happen that way. Time's up. Here we are. What say you, Supreme Court? That's what's going on right now. Anyways, appreciate you guys watching my videos, and if you'd like to learn the actual nerdy stuff and watch a 30-minute video on 922.0 and how Article 1 is invalid and it's not covered by Chevron deference, this is a great channel to watch. You're going to come out of there educated, and you're going to learn a whole bunch of knowledge. And if you're just looking for something entertaining, if you're looking for that 30-minute crushed down into one sentence and you want it to be entertaining, this is the kind of channel you can watch. But honestly, you should watch both of them. Because then if you want to question something that I say, well, here's basically the sources. I know people don't really put sources in descriptions anymore, but that's essentially how it works. Because it doesn't really matter. No one clicks on the description sources anyway, except for the weird people that wear aluminum foil hats. But anyways, I'm going way off into the weeds. Sorry, ADHD got the best of me. Anyway, if you guys would like to help support the channel, the best way to do it is shopping at OnlyTechFans at Shopify.com. Go there, buy cool stuff. Actually, I don't have any of the merch out right now. Anyways, if you guys would like to help support the channel and you don't want to shop at OnlyTechFans at Shopify.com, the best way to do it is go down and click on that Amazon affiliate link. Just by clicking on that link, even if you don't buy what that link is for, just clicking on it. Doing the Amazon shopping you were already going to do anyway. I'll kick back for it because you came there off my channel. Thank you for watching. Don't forget to subscribe.